All right, you guys, what up, what up, what up? Welcome to the channel. If you're new, don't be. Go ahead and click that subscribe button to be a part of the Witness gang, to join the Witness Nation. Now let's get into this, shall we? Hello, you guys, and welcome to the channel. If you're new, don't be.
I'm Whitney.
Keep it cute, get the boot. Your girl, as whack as she is in all her glory, was in the New York Times. All right, you guys, great afternoon. Good morning to you all, and good evening whenever you are watching this back. Disclaimer, this platform discusses any and all information that has been made known to the public in any way. I am not a journalist. I am a commentator. The views and opinions expressed in this video and on WhitneyD TV's YouTube channel do not necessarily reflect the opinion of WhitneyD and WhitneyD's YouTube channel. Now, all topics are for entertainment purposes solely. Comedy, satire, TV, mature. Viewer discretion is advised. Now, all commentary is alleged, but very real indeed. Great afternoon, everybody. Pray you guys are having a wonderfully stupid, blessed, ain't it a hump day? Hump day, to say the utmost least, you guys. Happy Thursday. Welcome to Evidence Over Emotions. Okay. The Road to Illinois trial for R.KELLY series. And from what I hear, he has been officially taken home. How about that? He's back in his home. We're going to get into all of that, okay? But where are you guys tuning in from? Let me know your city and your state by placing in the chat or in the comments, okay? Make sure you guys keep it cute or you will get the boot, all right? You know, anytime I get to talking about R. Smelly, it's a sensitive, funky topic. So I understand, but keep it cute. Oh, okay. Now, if you like to join the greatest show on YouTube, or one of them, you know, one of them. I'm biased. I'm me, the link is in the chat as well. You can find it by clicking out of the chat and clicking the join button and join, okay? Or you can visit the description box down below and the link is provided there, okay? Now, if you like to tip the hostess with the mostest, you can do so by sending me a super chat by clicking the symbol that is located in the chat box, or you can send me a cash app at WhitneyDTV87. Okay. Now, if you have a tip or you have an article of some kind of sort that you want me to look over and talk about here on Whitney D TV, send it to me via email at reviewswithWhitneyD@gmail.com, or you can slide in my DMs. Most people do. Okay. I got a lot of people that send me different articles, videos, and things of that nature. And I love it. I'm not even gonna lie to you. I love when y'all do that because it educates me. And then it just makes me tinker around with stuff like that. So not for nothing, if you would like to indulge or tickle my fancy about something, it doesn't have to be biased to any kind of way or whatever. But if it's just something that you want to point out to me, you can send it to me, or like I said, slide in my DMs. Do not, I repeat, you have been warned. Do not send me no trash pertaining to me. I don't care what nobody thinks or feels or says about me. If they can't say it to my face, they can say it to my okay. All right. Let me go ahead and get into the comments. However, I do want to say hello to all my beautiful viewers. Hello to all my ladybugs and my love boo bears. Okay, let's see. Uh-oh. Ashley, hey honey, long time no see. Got in here at 11:38 a.m. Central Standard Time. Okay. She says, yay. Hey honey. Katie, my head lead mod in charge. Thank you for this. She says this material is protected by fair use clause of the Copyright Act of 1976, allowing the rebroadcast of copyrighted materials for the purpose of commentary, entertainment, and education. Hey, Kamiko. Hey, honey bunches. You've been missing them. I missed you, girl, or whatever. She said, hello, Whitney D. Hey, honey. And all comments and opinions expressed are alleged and for entertainment purposes only. Hey, Nunya. Thumbs up. Yes, do what Nunya says. Put that thumbs up, all right? Hear ye, hear ye. PSA, please arrive and remain respectful or depart embarrassed by being removed. Thank ya. Hey, Nakia. I says, hey, girl. Hey, hey, honey bunches. West Coast Vales in the building. She said, good morning, good morning. Uh-oh. Gulfport, Mississippi in the building. Hey, honey bunches. Welcome, you guys. Welcome. Share this video, okay? Share this video, okay? So we have a few things that we're going to discuss. I'm hoping, child. I'm hoping that it's not too much, but we are going to discuss that R. Kelly has been officially transferred. I hope that would transfer the rest of you minds and counterparts out of New York. We are no longer there. Okay. Can we please move forward? All right. Because officially, all right, let me share my screen. Officially, R. Kelly has been moved to his second home, okay, of Chicago, you guys. So let's look into that, okay? Let me share my screen with y'all real quick, okay? We're gonna get into that later. But check this here out, okay? All right, it says R. Kelly transferred. Let me turn that off because I know anytime my hotline bling. All right, let me put myself down here. Okay. All right, as you guys see, it says R. Kelly transferred to Chicago prison ahead of trial. Okay, now this is today. All right, as you guys see here, this is official. Okay, R. Kelly resides where the money resides. Not really. Where the nothing resides. Okay. Before we get into this article, I want to welcome you guys to the road to Illinois, part one of the reading of the government's what was this? What we reading? The government's consolidated motions in limb. Okay, now what that means is we're going to hear what exactly is going to be brought into evidence and what they're trying not to be brought into evidence. Welcome you guys to the road to Illinois trial for R. Kelly. All right, you guys, welcome back. I had to turn my phone off, okay? But as we were continuing, okay, so R. Kelly transferred to Chicago prison ahead of trial. The article goes on to say singer R. Kelly has been transferred to a Chicago prison ahead of his trial in the city. The Bureau of Prisons confirmed Kelly has been transferred to the Metropolitan Correctional Center, okay? Now, Kelly was found guilty of leading a criminal enterprise that recruited women and girls. They forgot boys for sex. The charges also included a bribery scheme involving a public official to get a fake ID for Aaliyah, so the two could get married when she was 15. Now, y'all remember, okay, how we heard that there was no, there was no marriage certificate, and we discovered that that was a lie. That upon them doing their due diligence and all hunted over 100 devices found and materials and things of that nature. We found out that they had, and this is us reading the indictment, okay, for Illinois, that they found the marriage certificate, the license, and y'all remember the annulment, okay? All of those documents were found in their storage, okay? All right. Hey, Cat Talk. She says, hello, everyone. Hey, babe. Welcome. Okay. So that was confirmed. Okay, they did get married, and they soon thereafter got the marriage annulled. So we're not going to play those games no more. Okay. Says last month, Kelly was sentenced in a New York federal court to 30 years in prison. Kelly's attorney said he intends to uh, he intends to appeal in his conviction. Okay. Goes on to say in Chicago, Kelly is charged with running a years long scheme to buy back sex tapes he allegedly made with underage girls. The five alleged victims were all underage when prosecutors said they had sex with Kelly in the late 1990s. Prosecutors also charged Kelly and two associates, including manager Darrell McDavid, with a decades long conspiracy to silence victims and witnesses. Yikes. Now, you guys know we already, we know about this because we read the transcripts, okay? Now, if you would like to be locked in and caught up, okay, you guys just tune in here at Whitney D TV, where we make sure that we do our due diligence to keep you guys abreast as to what is going on. That's in part why I created these series, to keep everybody informed, okay, to keep everybody educated in regards to what is going on in trial. Okay, so that brings us to today's read. Okay, now this is in part a total of 43 pages. However, I'm going to try my best to chop it down to size. That's why I'm doing a podcast for part one of this read. And then on tonight, we're going to come back here, I think it's 7:30, if I'm not mistaken, to finally finish out the read. Okay. So I'm going to read as much as I can here without this video being lengthy. Okay. So we're going to go ahead and get into it. And on here, which you guys are going to be able to hear about the participation of the parents. You're going to hear about a lot of information. You're going to hear about the lie detector test and part of what he had, Lisa Van Allen, the alleged extortionist. And I broke that down to you guys on yesterday. But you're going to hear about, the evidence that they're going to use from the freaking lie detector test that they had to take. All of that. You're going to hear about all of that. And you're going to hear about what they're wanting to conceal in the trial. Now, see, if people actually read these, they will understand why certain evidence wasn't admissible or wasn't entered, or why parents weren't on trial, or why they were. This is the information that you get from when motions are in limb and things of that nature. And some people are not understanding, well, why was that brought? Well, this is why, sweetness. Everything is in document. Okay, so let's go ahead and get into this read. I'm not going to hold you guys much longer. Okay, I pray y'all are doing good. Hope you got your coffee, your breakfast, or your brunch, or your snack pack wrap, and you guys are in for this read. Okay, let me get us some nice ambiance going. Let me turn up our little music a little bit. So I just want to be just bare while I'm reading. Okay, we go ahead and share my screen one more time for the one time. Okay, we're gonna get into this read. Boom shakalaka. Somebody call the doctor. Okay, let me get it nice and big and healthy for you guys there. Okay, all right. I'll put myself down here at the bottom. Anybody comes in, you guys, let them know hello, hello, and welcome to Whitney D TV. Give them a nice, friendly, southern, hospitable hug. Y'all know how we do here, okay? All right, so let me update. I'm gonna update the banner so you guys will know what exactly we are reading here. Yeah. All right. Save that, and boom. All right. Now I'm gonna remove myself off the screen. Boom. All right, so that's what we're reading today, you guys. Government's consolidated emotions in Liam. The road to Illinois trial for R. Kelly. So let's go ahead and get into this read, shall we? Okay. All right, as you guys see, this was filed back in June 13th of this year. So I'm giving you guys abreast. Okay, we're in this. Just we're a month away. Okay, but I want to get you guys caught up and get you guys all of the information to catch you guys up. We are fastly approaching this trial next month. Okay, so I'm doing a due diligence of weekly updates in regards to getting you guys caught up. Okay, all right. So goes on to say government's consolidated motions in Liam. Okay, the United States of America through its attorney John R. Losh Jr., United States, excuse me, attorney for the Northern District of Illinois, respectfully moves the court in Liam for entry of orders admitting or excluding certain evidence. You hear that? What I just tell y'all. Okay, this is what it's going to tell you what they're trying to go ahead and put out there into evidence and what they're not going to. Okay. I try to tell you guys that it's a very informative process on both parts. Defense and prosecution always knows what is going on. Katie says, I'm in the bushes getting ready for a video conference with my VA education advisor. Okay. All right. No problem. Good luck. Okay, let's go ahead and continue, you guys. All right. And argument at trial in the case as set forth below. One, motion to protect the identities of certain victim witnesses. Okay. So as you guys know, we hear a lot of Jane Does, and it ain't gonna be no John Does, unfortunately, in this particular. I mean, fortunately, because we don't want no victims. I jokingly say about it, but we really wish there was no victims in this situation, but I concur, okay? But that's why you hear a lot of minor one, minor two, because this is to protect their identity. Although we do know, based off of experience and due diligence, that, minor one is Rashonda Lanfair. So we know that without a shadow of a doubt. Um, Let's continue. The government moves to protect the identities of the victims named in the superseding indictment referred to as minor one, minor three, minor four, and minor five, and minor six. The victim witnesses, okay, who are expected to provide and or will be the subject of sensitive and personal testimony concerning illegal sexual abuse and the production and receipt of child pornography by the defendants. Specifically, the government moves the court to one, permit the victim witnesses to testify using their first names only. Okay. Limit references to each of the victim witnesses in open court to their first names only. Oh, wow. So, interesting enough, as we read here, you guys, okay, that they're going to be permitted to testify using their first name. Okay. So it won't be any type of aliases, if you will. We're gonna know by first name. Wow, that's interesting enough. So I mean, it'll be like, Rashonda Ledford, it'll be Rashonda. You know what I'm saying? Wow, I'm interested to see who are these participants, who these witnesses are. Limited references to each of the victim witnesses in open court to their first name only and prevent public disclosure via cross-examination or otherwise of the victim witnesses' respective addresses or names of family members or exact places of employment, if any. The superseding indictment charges defendant Kelly with multiple counts of sexual enticement and exploitation of the victim's witnesses. The victim witnesses are expected to testify if explicit detail or be the subject of highly sensitive and personal testimony concerning illegal sexual contact with them that occurred when they were between the ages of, say it with me now, 13 and 17. Okay. Mind you, all right, that is more so for, well, I don't know who it's for. Let me be quiet. I'm just gonna read. But as you guys see, 13 and 17, but we already know that technically it was really 16, but they trying to give some grace there. The oldest one was 16 years old, but I concur. Due to the sensitive nature of the testimony and evidence relevant to the crimes charged, the government seeks entry of a proposed protective order. Okay. Limiting the disclosure of the victim witnesses' last names and other identifying information in court. Limited protections requests by the government are necessarily inappropriate to protect the victim witnesses' safety and well-being. Avoid harassment of the victim witnesses by the press and others, and prevent undue embarrassments and other adverse consequences such as retaliation by Kelly's supporters, relocation, or loss of employment. So basically, by them, not disclosing their name, they're trying to avoid all of this mishap. But with these Looney Tunes, I don't know if they're going to actually be able to stop it. I think they're putting precautions in now with how they're dealing with a lot of these crazy Looney Tunes fans, as you guys see, and YouTubers and things of that nature. I think they're going to be really, bulking down on that. In addition, the government anticipates that minor one's mother, listen to this, you guys, and this is Rashonda Landfair, minor one's mother will testify about similar topics related to minor one, including Kelly's long-term abuse of minor one while she was a child. As a result, the government similarly moves to permit minor one's mother, who has the same last name as minor one, to testify using her first name only. So again, like I told you guys, upon reading the indictment, that parents are going to be participating, right? And on the contrary, on last night, as we was reading, they called him daddy too. As I stated, I said, I don't give a damn. You're participating now because you're trying to save your behind. But on the contrary, you weren't doing this years back when you was cashing those checks. Right? Yeah. Anyway, but whatever, girl. Go on, girl. Go off. Good. The proposed protective order also contains a provision related to individual D, who will testify. Now, mind you, we know who individual D is. Okay. We know who individual D. Okay. And if you guys don't know, Lisa Van Allen. Okay. Lisa Van Allen is individual D. Okay. Goes on to say who will testify about, among other topics, sexual contact that she had with Kelly and minor one over the course of several years. So Lisa Van Allen, not only so we already know it's a video out there, remember? And that if you guys remember the interview that she did with Vlad TV, he asked, well, was it the video in question from years back, the golden shower video? And she was like, no, it's another video. All right. So out of the 4 videos that they have, one of those videos, Lisa Van Allen can confirm and identify Rashonda Landfair, and herself in it. That's very interesting. So we already know right there that Lisa Van Allen is going to be in court giving her testimony over the course of several years. Now, the government seeks to preclude disclosure of individual D's address, names of family members, and place of employment at trial and during pre-trial and post-trial proceedings in this case. This case was charged in July of 2019, and since that time, the case has garnered significant attention from local and national media sources. The same is true for Kelly's federal prosecution in the Eastern District of New York, EDNY. United States versus Kelly case number 19, CR283. And y'all, that's exactly the information that you need to be able to look up a case. Okay, this is it right here. This is what I'll be doing. Okay, in the case, the court granted government's motion to exclude references to victims' last names and other personal identification information during the trial, although we know a lot of the information was thereafter leaked, though. A lot of it was leaked, a lot of it was revealed. Case in point, here at Whitney DTV, we did some of the leakation, if you will. We kind of knew who victims was, but this was like during the trial as it was as it was going on and reading testimony. A balancing of the risk to the victim witnesses against the defendant's interest supported permitting the requested limitations. The victim witnesses testified about humiliating and explicit acts of abuse, some of which took place when they were minors. The same protocols are warranted in this case. Several district courts have excluded mention of victims' full names at trial, citing the privacy interests of the victim. And you can see this particular case law, okay? Goes on to say in sex trafficking case, protective order entered precluding reference to adult victims' last names and requiring all documents disclosing the last name of any victim to be filed under seal. Okay. United States versus Garner, number 16. Well, this particular case law, as you guys see, collecting cases. Okay, this particular case law says, given the anticipated explicit and sensitive nature of the evidence in this case, the government has a compelling interest in limiting identification of the victims. Okay, this particular case law citing excluding mention of adult and minor victims, full name, full last names at trial, as the government has a legitimate and substantial interest in protecting these witnesses from the likely adverse personal, professional, and psychological consequences of publicly linking their identities to their past lives as sex workers. Okay. Goes on to say, as the Garner court held, excluding evidence of the victim's full names inconsistent with the Crime Victims' Right Act, 18 U.S.C. 3771A8, which states that a victim has the right to be treated with fairness and with respect for the victim's dignity and privacy. 2016 WL 5404207 at 6. Additionally, the government has an interest in encouraging crime victims, particularly victims of sex crimes, to testify, protecting them from some of the adverse consequences of their testimony. Okay. And it says, see this particular case law. Now, while the public has a constitutional right of access to criminal trials, that right is not absolute. Okay, so hello, I hope you guys are hearing that. Okay, just because you feel like, oh, we the people should know, we the people should see evidence, and I try to tell the dimwits that, okay, it's to a certain degree. Okay, to a certain degree, are we permitted to be able to see child pornography? You know what I'm saying, or explicit content and things to that nature and stuff like that. Like, come on now, like let's be realistic here. In this particular case law states that a court can inhibit the disclosure of sensitive information when it is narrowly tailored to serve a compelling governmental interest. Okay, ID at 607. In this case, the exclusion of the victim's last names, while otherwise allowing their testimony in open court, is narrowly tailored to serve the interest in protecting the victim's privacy rights. Okay, and I wanted to point this particular part out because I had somebody let me highlight this, okay? I had somebody make a comment and they are trying their best to do due diligence of like tear up tear up Lizette. Now, many of you guys know I interviewed Lizette in part with her book that she had just came out, Jane Doe number 9. And on the contrary, she was not physically in court, but you also saw her come in and speak at sentencing and on sort. And I mean, her testimony stood. Okay. Now, people were in the comments stating, well, that's why they didn't use her testimony. You dimwits, they did. That's why her name, her book is titled Jane Doe Number 9. She was on the indictment, sweetie. And you don't necessarily have to be at the court to be able to have your testimony be heard. And her testimony was definitely heard. And that's why she was able to then come in on the sentencing to be able to speak, for that. And I was trying to tell people that, in the comments, like, that's why she has the title to her book, Jane Doe Number 9. She was on the indictment, sweetie. And a lot of people don't know that. Ashley says, I'm here listening. Hello, chat, and hello, lovely Whitney. Hey, honey, bunches. You was in here bright and early. Let's continue, okay? And it tells you see this particular case law, okay? And it goes on to say that the court cannot envision a protective order bearing mention of victim's full last name that is more narrowly tailored to serve the government's compelling interests, okay? And then it tells you see this particular case law. It goes on to say excluding mention of an adult victim's full name, a full last name at trial, explaining that use of the victim's full name would add nothing substantive to her in court testimony that cannot be supplied by the use of her first name and first initial of her last name. For the reasons set forth above, the government respectfully requests that the court grant the government's motion and permit the victim witnesses and minor one's mother to testify using their first names only. So y'all, again, like I said, Rashonda Landfair's mother will be speaking and will be cooperating. And I'm telling y'all, hear me now. I haven't let y'all wrong yet, okay? What I'm thinking is she's cooperating with the government. Why? Because her butt will be thrown up under the jail, okay? And so the thing is, just like Lewis, as we heard with his testimony, to be able to, get a shorter sentencing or what have you, they wanted his testimony. And now look, he's free. You know what I'm saying? So what I'm thinking is that Rashonda Landfair's mother is trying to cooperate and give her information and let them know what happened and why she got into that position and what had happened was so she can save her behind. Okay. So she will be testifying. We will be hearing from Rashonda Landfair's mother. 2, limit references to each of the victim witnesses and minor one's mother in open court to their first names only. And 3, prevent public disclosure of addresses, full names of family members, or exact place of employment, if any, for the victim witnesses, minor one's mother, and individual D. The government further requests that the court enter the attached protective order that sets forth the government's request relief. The proposed protective order supplements the existing protective order in the case R53, which contains several provisions regarding the disclosure of discovery materials produced in this case, including prohibition on excluding any information marked as sensitive in any public filing with the court. 2, motion to preclude evidence of victims' sexual history. For the reasons set forth below, defendants should be precluded from eliciting, my bad, on cross-examination or otherwise introducing evidence or making arguments as to the sexual behavior of the victim witnesses with individuals other than Kelly or others at Kelly's direction. Okay. A, the evidence is inadmissible under Rule 412. By its plain terms, Rule 412 bars evidence of a victim's sexual history and sexual predisposition in cases including allegations of sexual misconduct. The following evidence is not admissible in a civil or criminal proceeding involving alleged sexual misconduct. 1, evidence offered to prove that any alleged victim engaged in other sexual behavior, or 2, evidence offered to prove a victim's sexual predisposition. Okay. The purpose of the rule is to safeguard the alleged victim against the invasion of privacy, potential embarrassment, and sexual stereotyping that is associated with public disclosure of intimate sexual details, and to encourage victims of sexual misconduct to institute and to participate in legal proceedings against alleged offenders. Okay, see this particular case law. It says this purpose is consistent with other provisions of federal law, which provide that all crime victims have the right to be treated with fairness and with respect for the victim's dignity and privacy. Okay, 18 USC 3771A8. Consequently, Rule 412. Hold on one second, y'all. Okay. Interpreted broadly and applies to all sexual behavior of the victim before trial. This particular case law, whether offered as substantive evidence or for impeachment. Okay. Federal REVID or evidence 412 adversary committee notes. Okay. Rule 412 imposes clear limits on a defendant's ability to introduce evidence that a victim engaged in other sexual behavior or has a propensity to engage in sexual acts. In the context of criminal cases, the rule prescribes very limited exceptions to this in admissibility. Okay, so what I'm gathering here, just to keep it short and funky and cute, is basically, hold on one second. Sorry, y'all, baby came in. Okay, so what I'm gathering from here, to keep it short, funky, and cute, is basically that whole thing of that the words that we use in the sense of, oh, she's fast, oh, she was hot, she was sexually active already. You get what I'm saying? So you can't say that. You can't use that. Oh, well, she wasn't a virgin. Oh, well, and we heard that a lot when it came to Azrael. Remember, they were saying that a lot in the case of she had a boyfriend, and and she was in the institute, crazy institute before that, and she went it's not going to be admissible in court. Basically, that's what to put in a cute little bow. The court may admit the following evidence in a criminal case: A, evidence of specific instances of a victim's sexual behavior if offered to prove that someone other than the defendant was the source of semen injury or other physical evidence. So, case in point, I mean, like I said, it's really self-explanatory. So basically, they'll put it in there and they'll be like, well, it couldn't be my client because that same day she had sex with her boyfriend. You get what I'm saying? Stuff like that. So that's what they're saying. Okay. See, B, evidence of specific instances of a victim's sexual behavior with respect to the person accused of sexual misconduct, if offered by the defendant to prove consent or if offered by the prosecutor. And C, evidence whose exclusion would violate the defendant's constitutional rights. Okay. All right. Okay, we're about to go on the 40-minute mark, you guys. Let me take a quick break, just wet my whistle, and I will be back here soon. Suja, meaning long, beautiful life, embodies the promise that flows from the cold-pressed beverages it delivers in each and every bottle. Now, today, they carry on their founder's mission to get the best quality, organic, and non-GMO beverages into as many hands as possible. Now, I am happy to say I am one of those hands. Yes, I'm Whitney D of Whitney D TV, and I am a proud ambassador of Suja Juice. I love, personally, their vibrant probiotic juice, and their immunity elderberry shot stopped me and my family through the roughest times of COVID-19. Now, if you want to find a quick and resourceful way to take on all of your vitamins and nutrients, try sujajuice.com. Visit the description box down below to get more information and let them know that Whitney D or Whitney D TV sent you. Bye. Sujajuice.com, okay? And you can actually pick up this juice at any of your retail stores, Walmart or Whole Foods. I am a brand ambassador, okay? Sujajuice.com, okay? All right, you guys, we are back, okay? All right, I'm gonna read a bit more into this, but like I said, I'm not gonna go over an hour. I don't want to be, abrasive with this video, okay? So let's continue, all right? Okay, if a defendant intends to introduce evidence of a victim's other sexual behavior or alleged sexual predisposition under one of these exceptions, the rule requires the filing of a seal motion no less than 14 days before trial that specifically describes and states the purpose for which it is to be offered, with notice to the victim or her representative. In this particular case law. Now, none of the limited exceptions to Rule 412 apply in this case, however. Kelly is charged with enticing each of the minors named in the indictment, okay? So every last one of those victims, every last one of the minors, he has been charged with, okay? All right. It ain't nobody in here that, just shooting the ish. No. He's been charged for each one of them. Okay. Engaged in sexual contact and acts with him repeatedly over the course of years. Here, any evidence of a victim's sexual behavior with anyone other than Kelly or others at Kelly's direction, as well as any evidence of any perpetrated sexual predisposition would be wholly irrelevant to the charges against the defendant. The exclusion of evidence on these topics is thus appropriate under Rule 412. In this particular case law, okay, prosecution affirming district court's decision to prohibit the introduction of evidence suggestive of the minor victim's sexual predisposition and her previous sexual activity with a male depicted in photos on her phone. B, the evidence is inadmissible under Rule 403. Even if evidence concerning the victim's other sexual conduct was relevant, it is not. Any probative value would be marginal at best and substantially outweighed by the dangers of unfair prejudice, confusion of the issues, misleading the jury, and embarrassing the victim. And it should be excluded pursuant to Rule 403. In particular, such evidence would provide for the substantial risk that the jury will question the victim's sexual morals and view them as untruthful because of their prior sexual activities. For all of these reasons, any inquiry or evidence related to the victim's sexual history is probably excluded under Rule 403. Motion to bear evidence and argument related to consent. The government requests that the court prohibit defendants from introducing evidence and arguing that the minor victims consent to engaging in sexual activity while they were minors. Now, this is good. This is where it gets good, you guys. Listen to this. Listen to this Looney Tune, okay? All right. And I do mean Looney Tune in the sense of R. Kelly. And this is a lot of what these fans be talking about. Okay, listen to this. Hey, Isha, check this out. It is well established that minors lack the capacity to consent. And so sexual contact with a minor is always without consent. Do you hear that? Don't matter if they mama text them and said, hey, sit on his lap, do this, do that, wear this, say this, go there. Hey, doesn't matter. If the daddy said, oh, to heck with my daughter, you can have her. I don't care. Here she is. Here she go. Here, sign, seal, deliver. Minors lack the capacity to consent. And so sexual contact with a minor is always without consent, period. That's why at the end of the day, it falls back on R. Kelly. Period. It don't matter if a parent, a sister, a mother, whatever, whoever. I told y'all, it don't matter if they hand sealed, delivered, gift wrap their children, butt naked with a bow on their forehead to this man. He was supposed to call the police. He was supposed to turn them away, but he didn't. And in Illinois, you're not gonna be hearing none of this. Well, the parent, nope, they're already making sure that this is not presented in court. No, Whitney, yeah. Let me run that back. 3, motion to bear evidence and argue related to consent. The government requests that the court prohibits, they're trying to stop it, prohibits the defendant from introducing evidence and arguing that the minor victims consented. They wanted it. They knew what they were doing. Well, the parents gave them to them. Yeah. They're prohibiting that argument. This particular case law, let's read it. It says, because the district court was correct as a matter of law that consent is not a defense to the crime's charge, it was not an abuse of discretion to exclude the consent evidence. This particular case law goes on to say that the minor consents to engaging in prostitution is not a defense to the crime of trafficking, a minor for purposes of prostitution. Okay. Goes on to say in Rappelinger, the defendant was charged with sexual exploitation of a minor in violation of 18 U.S.C. 2251A and E, distribution of child pornography in violation of 18 U.S.C. 2252A1 and B1, and possession of child pornography in violation of 18 U.S.C. 2252AA5B and B2. The defendant agreed that consent was not a defense to the distribution or possession of child pornography charges. However, at trial, he sought to introduce evidence of the minor's consent of the sexual exploitation charge. Specifically, the defendant sought to introduce evidence that the minor victim consented to engage in the sexual behavior and lascivious exposition. Okay. On appeal, the Eighth Circuit rejected the defendant's argument that such evidence should have been admitted and concluded that because the district court was correct as a matter of law that consent is not a defense to the crimes charged. Y'all hear that right? Let me run that back. So just because you want to say Oh, well, no, they were okay with it. Oh, no, she said she wanted it. Oh, yes, you still broke the law. Oh, no, 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 no. But I got a waiver from the parent, and they basically sold their daughter to me. Oh, no, no, no. No, the mom, I talked to the mom, and she went and bought the cassette. She went and bought the CD. Like, everything is good. Everything is okay. No, it doesn't work that way. Sorry, y'all. It doesn't matter, because basically here it says, because the district court was correct as a matter of law that consent is not a defense to the crime charged. Again, why the parents aren't? It don't matter. Is it wrong? Absolutely. But it's not the crime that is being charged here. It was not an abuse of discretion to exclude the consent evidence, okay? The Eighth Circuit further held that the jury was properly instructed that a minor may not legally consent to being sexually exploited. The Ninth Circuit's decision in United States versus whoever these people are, as you guys see, is also illustrative. The defendant charged with enticement of a minor in violation of 18 U.S.C. 2422B proposed a jury instruction that would have required the jury to acquit him if it found that the victim induced him and was at least partly willing to engage in the alleged content. Well, Your Honor, this can't be so, because the mama helped her daughter to entice and taught her how to get R.Kelly. No, 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 no. This. The trial court refused to give the instruction. In affirming the defendant's conviction, the Court of Appeals wrote the following: the defendant's argument collapsed because he misconstrues the nature of the liability under 2422B. His proposed jury instruction reflects this mistake. In effect, the defendant claims that entrapment by the victim ameliorates any inducement on his part. Again, this reading of the statute mistakenly changes the focus from the defendant to the victim. What about the parents? But she was hot. She was fast. When you do that, people, it literally takes the focus from the defendant to the victim. And this is the reason why I myself personally stay focused. The victim's willingness to engage in sexual activity is irrelevant. In much the same way that a minor's consent to sexual activity does not mitigate the offense of statutory rape or child molestation. So long as a defendant's actions constitutes the act of persuading, inducing, enticing, or coercing a minor to engage in criminal sexual activity, 2422B applies. Now, in United States versus Die, or this particular case law, the Third Circuit rejected a similar arguments. In that case, the defendant was charged with enticing a minor in violation of 18 U.S.C. 2422B and traveling interstate for the purpose of engaging in illicit sexual conduct in violation of 18 U.S.C. 2423B. At trial, he admitted to the conduct alleged by argued that the government's evidence against him was insufficient because the purported minor was a seductress who had persuaded, induced, and enticed him not the other way around. Yikes. Y'all hear that? So in this particular case law, this dude basically was saying, well, the little girl enticed me. The Third Circuit rejected this defense, rightfully so. Defendants' hot to trot defense is especially troubling because it's underlining premise is that it is possible for a 14-year-old child to seduce a 35-year-old man, absolving the man of criminal liability for engaging in or attempting to talk the minor into engaging in illicit sexual activity. Now, the defendant cites no case law, however, to support the notion that minors who are by law unable to even consent to sexual activity, this particular case law, can ask for it. Ain't that what we hear? They asked for that. They knew they were getting themselves into. Blah, 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 blah. Played a little small violins in such a way that it becomes legally permissible for adults to entice minors into sexual escapades. In this case, consent is not a defense to the charges in counts 1 through 4 and 9 through 13 of the superseding indictment. Whether any of the minor victims allegedly agreed to engage in sexual conduct with or at the direction of Kelly is irrelevant to whether Kelly is guilty of the violation. Boom, bada, bing, bada, boom. So regardless, if they wanted it, if the parents sold them off, if anything, it was up to R. Kelly to not receive the bait. So while y'all are crying about some freaking text messages still, while y'all still tripping behind these parents, you are taking away the blame. It is all irrelevant. Do we hear about these shiesty parents? We do, especially in this particular trial. But at the end of the day, R. Kelly is the one who violated these laws. And even more so, he's the reason why we are in court, not nobody else, not even the parents in Rashonda Landfair's situation. They didn't know what was going on originally. But when it became an issue is when they found out, and they continue to allow this to continue. But did they break laws? Yeah, sure enough. But it's solely up to R. Kelly. He did this. Hey, Layla says Robert has zero self-control and needs to rot in prison. I second that. Hey, Purple says, good morning, Mrs. Whitney and Chad. Good morning, beautiful. Let's wrap this up, you guys. Says Kelly, Kelly is guilty of violating 2251A or 2422B. Therefore, evidence and argument related to the victim's consent is irrelevant and should be excluded at trial. So kudos to these lawyers. They're basically saying, don't you dare bring up the fact of the matter that, oh my God, they wanted it. Nope, not going to be in this trial. This includes questions during cross-examination of victims about whether they consented to having sex with Kelly or others while they were minors. Such questions would call for witnesses to make legal conclusions and should be barred. For all of these reasons, the court should grant the government's motion to bar evidence and argument related to the minor victim's consent. The government will offer instructions on this issue in its proposed jury instructions to be submitted at a later date. Okay, so we're going to stop right here and we're going to continue this read on tonight. Okay. Wow, we just heard a lot. We just heard a lot here in regards to the government's consolidated motions in limb. The road to Illinois trial for R. Kelly. Now, this was submitted, as I stated, on last month, okay? And we're catching ourselves up full steam ahead in regards to this trial for Illinois, okay? We are full steam ahead to Illinois trial. So we are getting caught up here on WhitneyD TV. Melissa says, he could have said no. That's simple. Thank you. That's why it's just ridiculous and preposterous to me that people are still talking about these stupid text messages, that people are still talking about parents of any kind of magnitude. Okay. And like I said, I'm against the land fairs in regards to hearing all this crap about Illinois. However, it still falls back on R. Kelly, period. And I'm not going to waste my time with videos talking about parents. I'm just not. Okay. Because at the end of the day, it's his responsibility. And I give you guys constant examples. I was in childcare, for years, seriously, since the age of I think I was 17, 18. I got my certification to be a childcare provider. I got my CCMS. There you go. My CCMS certification here in Texas. Basically, for those that don't know, you're able to basically have a freaking child care center within your home. I did that because my family members, and I'm not going to say who, but a few of my family members got sexual abused by their child care provider because they had an in-home child care institute, and they got sexual abuse. And so to save them, that's when I first got into childcare, and I got my CCMS certification so I can be certified to be able to, house them and watch them on behalf of this relative, right? And I just continued to be in the system. And so I went from doing it in my home to going into facilities, basically, daycares and things of that nature. And so I had, the opportunity to facilitate babies, from out the womb all the way up until school, what we call school age, where they were in, all the way up into, I want to say they were elementary headed to junior high. That was the cutoff, right? So they were like, I want to say, oh gosh, like 11, 12, I think was the cutoff, and they had to get out the center. But not for nothing, I had the little boys, trying to be cute and trying to be cool, whatever, trying to crush on me and stuff like that. But I nipped that stuff right in the bud because I don't have an attraction to no kids, and I don't feel like that's cute and it don't tickle my fancy. And I think it's very disgusting and disturbing, to say the utmost least, or whatever the case may be. And I even feel like that when it be a very huge gap in age when it comes to girls, even boys. Yeah, I mean, if it's an old woman and you mess around with a kid, I think that's disgusting. I think it's disturbing. I'm not sexist by far. I believe that on the flip, if it's an old man messing with a young woman, I feel like that is just absurd, to say the least. So no, I don't see it being a situation where we have to continuously looking at parents and stuff like that. Yeah, do you have shiesty parents out there? Absolutely. But at the end of the day, it still falls on that predator. It still falls on that person that's doing the victimizing at the end of the day, hands down. But you guys, that is the video for me. Ashley says Kelly was a grown man and knew this was a crime and wrong, so he is to blame, period. Okay, that's how I feel at the end of the day. Thank you guys so very much for tuning in to another installation of Evidence Over Emotion, the road to Illinois trial for R. Kelly series. Okay, this is part 1 of the government's consolidated motions in limb, where we find out what they're gonna strike down in court and what they're trying to allow in court. Okay, I will be back tonight for part 2, basically the continuation of this read along as we continue weekly to get ourselves caught up. We're technically just right now a month back. Leda says, my neighbor's son had the biggest crush on me when he was a kid. He would go on about when he becomes older, he would marry me. Now he's legal and he's still a little boy in my eyes. Exactly. I mean, it's like, girl, like, that's why I just it's just a no-go for me. I don't find it to be cute at all. Thank you. Yes, like Melissa says, please hit the like button, y'all, and share this video so we can get the world informed, because a lot of people aren't as informed as we are here at Whitney D TV. They are still in the New York case and trial. And I know some people are wanting to catch themselves up, but baby, it is over with. Let it go. Let it go. Not for nothing, you guys. I will see you guys back here on tonight. Same bat place, different bat time, 7:30 for the continuation of the Road to Illinois trial for R.KELLY series. Okay, as we conclude these particular transcripts. Okay, I see you guys on tonight, and I love you guys. Until next time. Don't you just love trolls? Said no one ever. What if I told you I know how to minimize, virtually erase your channel trolls? Yeah, that's right. Hi, I'm Whitney D of Whitney D TV, and with my two-step process, get your trolls under your thumb. What does trolling mean? To antagonize others online by deliberately posting inflammatory, irrelevant, or offensive comments, or other disruptive content. Trolls engage in the most outrageous and offensive behavior possible, all the better to troll you with. As a content creator myself, I dealt with trolling head on into the start of my YouTube career, and it was devastating. As time went on, however, I discovered settings and controls that helped me minimize and virtually erase trolling, and I loved it. Doing these easy steps changed everything. Click the link below to get my ebook on how to stop trolling. I'm Whitney. Keep it cute, but get the boot.